appeal in the matter of HMRC and Malde and another.
Mr Hayes.
My Lords, I appear on behalf of the Appellant HMRC with the assistance of Mr Way, and my learned friend Mr Webster of King's Counsel and Mr Gurney appear on behalf of the respondent taxpayers.
Yeah.
By way of overview, this is an appeal by HMRC against the decision of the Upper Tribunal, Mr Justice Johnson and Judge Greenbank, dated the 7th of November 2024, and relates to 3 grounds.
And I should say we have read extensively, so we know the landscape.
I'm grateful. In that case, I was going to give a very brief overview in relation to the trader Sintra SA, who doesn't feature with respect of these appeals.
Yep.
That trader spanned from the period of 2004 to 2011. HMRC issued a dishonesty penalty under Section 60 of the VAT Act and transferred that to Mr Malde under Section 61. The FTT found, contrary to Mr Malde's assertion that he in fact controlled Sintra SA, and concluded that Sintra SA had smuggled alcohol into the UK and sold it, dishonestly failing to register for VAT and submit VAT returns. However, with respect to the issue of quantum, the FTT concluded that the assessment had not been quantified to best judgment, and so set aside the entirety of the £11 million assessment and director's liability notice. HMRC appealed that finding on the basis that the FTT misapplied the test for best judgment. The UT agreed, and the question of quantum has been remitted to the FTT, but by agreement of the parties, that matter is stayed behind this hearing.
Yes.
With respect to Sintra Global, which is the focus of this appeal, that traded from 2011 to 2014. The FTT found the burden of proof was on HMRC, but that HMRC had not discharged the burden of proving that Sintra Global was the owner of the goods at the point they were physically supplied in the United Kingdom, and so consequentially dismissed the various liability to be registered and penalties and personal liability notices. HMRC appealed that finding as the burden of proof to the Upper Tribunal, but the Upper Tribunal dismissed HMRC's appeal, concluding that all relevant aspects of the penalty appeal, save for the issue of quantum, that the burden was on HMRC. And if I could just take the court to the concluding paragraph, which can be found in the core bundle, tab 6, page 110. And we see at paragraph 133, the Upper Tribunal concluding, for all these reasons, in our view, the FTT was right to conclude the burden of proof fell on HMRC in relation to all relevant aspects of the penalty appeals, with the possible exception of the quantum of the penalty assessment. Although it is not directly relevant, we take comfort that our view is in line with the guidance of Commonwealth Law Justice in Khan in relation to the previous penalty regime. And my lords, I'll come to the submission in due course, but we say the Upper Tribunal misapplied the guidance in Khan. The Upper Tribunal's decision was clearly based upon Article 6 and the presumption of innocence as to where the burden of proof fell, and that can be seen on the previous page, page 109 in paragraph 131. Paragraph 131, we will not follow that approach in this case, and there it's referring to the Upper Tribunal decision Zaman. These are penalty appeals. The general rule is that the burden is on HMRC to prove all aspects of these appeals that relate to the imposition of the penalties, consistent with the presumption of innocence in Article 6.2 of the ECHR. We should only depart from that rule where a justifiable and proportionate exception to the presumption can be justified on the facts and circumstances of the case. And finally, while I'm on this page, if we go to paragraph 129, just above that, the point I seek to make is clearly the burden of proof was material in this matter, and the UT said so. 129, as we've described, those points were decided by the FTT's conclusion that there was an absence of evidence that Global was the owner of the goods that were supplied in the UK. That conclusion, which was clearly based on its decision on the burden of proof, in effect decided all the penalty appeals in the appellant's favour, with the exception of the appeal against the DLN that related to Sintra SA. And just by way of concluding introductory remarks, just in case this court is wondering why the FTT was satisfied that Sintra SA was the owner of the goods that were smuggled into the UK, but not in relation to Sintra Global. HMRC's case was that during the Sintra Global period, a buffer trader called Edwin was inserted into the supply chain or named on the cover paperwork that was provided to customs officers if a load got intercepted at the border. But HMRC's case was that Edwin was just named on this cover paperwork in order to frustrate detection and confuse matters, but in actual fact, Sintra Global was still smuggling in the mirror loads, the smuggled loads, and selling them, and so that was not Edwin or anyone else. However, the FTT found HMRC had not discharged the burden with respect to that. My lords, before coming to ground one, I intend to make 4 preliminary points. The first of those is that on an appeal against an assessment or liability to tax, with a few notable exceptions, the general rule is that the burden of proof is on the taxpayer to show that the assessment or liability is wrong, and the burden does not change merely because allegations of fraud are involved. If I could ask the court to stay in that tab, the Upper Tribunal decision at page 93 and paragraph 68. The UT summarises the case law and the reasons as to the burden being on the taxpayer with respect of assessment and liability to tax. Paragraph 68, subject to certain exceptions to which we will return below, on an appeal against an assessment to tax, the general rule is that unless the statute expressly or impliedly provides otherwise, the burden is on the taxpayer to show that the assessment is wrong and to establish the correct amount of tax that is due. The rationale, paragraph 69, for this rule is variously expressed in the cases. In some cases, it is referred to as a product of the statutory rules that an assessment will stand good unless it is successfully appealed, such as in section 50, subsection 6 of the Taxes Management Act. In others, it is expressed as an exception to the general principle that the person who asserts must prove on the grounds that the taxpayer is. In others, it is expressed as an exception to the general principle that the person who asserts must prove on the grounds that the taxpayer is usually in a position to produce the evidence that he or she needs to prove his or her case. In Khan, Lord Justice Khan Worth suggested that the rule may be a product of a broader principle that, subject to certain exceptions, the burden is on the appellant in the case of an appeal against an enforcement action taken by a public authority. There are some well-established exceptions to this general rule, paragraph 70. These are typically cases where a particular state of mind or particular conduct on the part of the taxpayer is an essential element of the liability for which HMRC contends. So, for example, in MTIC cases, which rely on the Cattell principle, it is for HMRC to show that the taxpayer knew or should have known that the transactions in which he or she was involved were connected to fraud. HMRC also have the burden of proving an allegation that a transaction is a sham, or that the transactions involve an abuse of law in order to invoke the principle in Halifax in VAT cases. And my lord, briefly with respect to the point that allegations of fraud do not alter that fact, could I refer the court briefly to the case, the Court of Appeal case of Awards, which is one of the cases you have in hard copy.
Yes.
And that point was succinctly made at paragraph 40, which appears at page 1590. The Court of Appeal, having gone through the cases of Brady and Ingenious Games, approvingly cites the Upper Tribunal at paragraph 40, and then indented 30, paragraph 36. Two principles emerge from Ingenious and Brady. Point one, the burden of showing an assessment is incorrect remains on the taxpayer throughout the appeal. This is so even if the circumstances of the case are such that there either must or may have been some fraudulent conduct on the part of the taxpayer which is relevant to the tax liability. And then it goes on as to the requirement about matters that should be put to witnesses, but we rely upon that first point to say that allegations of fraud do not alter the burden. The second preliminary point I wish to make is that Article 6 of the ECHR does not apply to tax assessments because tax disputes are not civil rights and obligations to which Article 6 applies. This is a well-established principle, and so I wasn't intending to take the court to the case of Ferranzi, but for the purpose of your note, that case can be found in the Authorities Bundle, Volume 4, at tab 51, and the head note makes that principle clear at page 1103 to 1104. What may be helpful, however, is to go through the 5 appeals that are the subject before this court now, because HMRC say one of those was an underlying tax appeal. The other 4 were either penalties or personal liability notices. So I think the FTT summarises the different appeals. So if I could ask the tribunal to go to the core bundle, tab 10, page 176. So here at paragraph 2, the FTT is describing the various appeals. At 2.1, there's the decision contained in the letter of the 16th of July 2015 that Sintra Global was liable to be registered for VAT. So HMRC says that is the one underlying tax appeal of the 5 that were before this court. As a consequence of that underlying tax appeal, there was a penalty issued against Sintra Global, which is 2 subsection 2. And that penalty was issued under Schedule 41 of the Finance Act for failing to notify, for Sintra Global failing to notify of its liability to register for VAT. What then happened, and what we then see at 3.1, is that that company penalty was transferred to the director, Mr Malde, controlling mind, via a personal liability notice, also under Schedule 41, making him 100% liable for the company penalty. At 3.2, we see an alternative, and it was very much pleasing, the alternative company penalty under Schedule 24 for an inaccuracy. So what happened is at a point during these proceedings, and I'll come to the reason why in due course, Sintra Global submitted a nil VAT return, essentially saying it didn't sell the goods in the UK, we don't owe any VAT. And so, as an abundance of caution, in case there are any technical issues with the Schedule 41 penalty for failing to notify, HMRC issued out of an abundance of caution an alternative penalty and personal liability notice under Schedule 24 for an inaccuracy. So you fail to notify Schedule 41, but if there are any technical issues there, we say that Schedule 24, there's an inaccuracy in the nil VAT return you put forward. And then finally, as far as this court is concerned, at 3, subsection 3, also under Schedule 41, but this time relating to excise duty, a personal liability notice just under 14 million for the handling of goods subject to unpaid excise duty. So the previous Schedule 41 related to VAT, the notice and appeal at 3.3 relates to excise. The appeal that relating to 3.4 was the Sintra SA matter, which isn't before this court. So on HMRC's case, there was one underlying tax liability, we see at 2.1. There was one company penalty, we see at 2.2, and there were 3 personal liability notices at 3.1, 3.2, and 3.3, albeit 3.1 and 3.2 were in the alternative. The third preliminary point I make is that HMRC accept the one company penalty and the 3 personal liability notices are criminal proceedings for the purpose of Article 6. But, and this is the ride that we'll come on to when we move on to ground 1 in a moment, whilst they are criminal proceedings for the purpose of Article 6, we submit that Article 6 does not necessarily apply to the whole of the proceedings if it is possible to separate those parts of the proceedings which engage Article 6 from those that do not. And we'll come on to make out that submission in due course. But the preliminary point I seek to make now is that we accept the penalties and the personal liability notices are criminal proceedings. They fulfil the Engel criteria, the 3-stage Engel criteria for that purpose, albeit we can say that they can then be separated. The fourth preliminary point I wish to make is to outline briefly the 3 different types of proceedings whereby penalties can be litigated before the FTT. So the first type I will badge as separate proceedings, and this would be where there is an underlying tax liability dispute, first in time, and that goes to final hearing. The burden of proof, unless one of the exceptions applies, is on the taxpayer. And if that appeal by the taxpayer is dismissed, so HMRC say assessment is upheld, there are then various statutes that allow a period for HMRC to raise a penalty or a personal liability notice within a certain period of time. And my lord, that was in one of the examples in the case of Kishore, which I'll come on to in a moment. What then happens is we then fast forward, that penalty appeal is then appealed, and we then come forward to a hearing with respect to that penalty appeal. And then the question is, well, can the taxpayer recontest that underlying liability finding which has been determined by a previous tribunal. My lords, this court in the case of Kishore made it clear that that question needs to be resolved on a broad merit-based test as set out by Lord Bingham in Johnson versus Gorwood, and that principle can be seen in the hard copy case of Kishore, which is before you, page 105, and the top of that page, Roman numeral 5. And the court summarised the various position with relation to issue estoppel and abuse, and then came to this conclusion. Whilst the point was left open in China, the weight of authority suggests that issue estoppel has at most a much smaller part to play in the context of tax appeals. However, it may be abusive for a party to contest a point which has been decided against him in such an appeal in later proceedings, and in that context, the court will again make a broad merits-based evaluation. The general rule of thumb, and I say this because I appreciate it, is one has to apply the broad merits-based test, but the way that that has been applied now fairly consistently in the FTT over the last few years is as follows, is that if the question of the underlying liability in the earlier tax appeal went all the way to judicial determination, the FTT has regarded it then as an abuse for that to be litigated again in the context of penalty litigation. However, if the underlying liability didn't go all the way to final judicial determination, or it relates to different VAT periods, by way of example, it's been regarded as not abusive for that issue to be litigated in the context of the later penalty litigation. The case, it's an FTT case, but it summarises a number of the authorities. The case of Trees, if I could just briefly take the court to that. That can be found in the Authorities Bundle Volume 2, tab 34, page 656. I've picked the case of Trees up here halfway through. This was an interim application an interim hearing in that case. There had been an earlier cartel finding against the company called CCA, and HMRC had subsequently issued a section 60 and 61 dishonesty penalty and director's liability notice. In his notice of appeal, Mr Trees, who was the controlling mind and director of CCA, sought to relitigate some of the findings of the initial cartel decision. HMRC sought to strike that out on the basis of abuse, on the basis that those previous matters had reached all the way to judicial determination. We see here at paragraph 38 the court, the tribunal in Trees, having regard to the Johnson and Gorwood principle. And then if we scroll down, the Court of Trees really discusses two different cases. If we scroll down to page 658, paragraph 46, here this is the FTT discussing Judge Berner's decision in a case called Hackett, and Judge Berner's reasoning, which it agrees with. And it says this, Judge Berner said this: So far as the 09-06 period is concerned, the relevant issues were the subject of final determination by the Tribunal in Intex 2014, having considered on a hearing of the substantive appeal all the facts and evidence, including the evidence of Mr Hackett. I have no doubt in that respect that it would be an abusive process for Mr Hackett to seek to relitigate the relevant issues determined by the Tribunal in that appeal. Mr Hackett, in his capacity as a director of Intex, has had an opportunity to put forward his case that in that period there was no connection between the transactions of Intex in that period and fraudulent evasion of that, and that Intex did not know of any such connection. It would be contrary to the principle of finality of litigation to allow that determination to be revisited on this appeal. It would be a clear abuse of process to do so. There are no circumstances that could justify such a course. However, if we go on to the next paragraph 47, there were also periods in relation, in the case of Hackett, in the penalty proceedings in relation to that period that hadn't previously been decided upon. And at 47, Judge Berner said this: the circumstances for other periods are different. In those cases, there has not been any determination by the tribunal, whether on a substantive hearing or otherwise. And then if we jump to paragraph 48, Judge Berner continued, in the case of the prior appeals of Intex for which, on account of the withdrawal of those appeals, there has been no determination of the facts and issues by the tribunal, it would, in my judgment, not be an abusive process of the tribunal for those facts and issues to fall to be determined by the tribunal on this appeal by Mr Hackett, e.g. the personal liability notice. And that same dividing line, that same principle, was further upheld in the case of Booth. If we scroll down to paragraph 52, Judge McNall, in the case of Booth, took the same approach. In that case, he was dealing with VAT periods that had previously been decided. Indented paragraph 73, I'm entirely satisfied that it would be an abusive process for the appellant now to seek to relitigate the relevant issues which were already determined by the FTT in 2017. I'm entirely satisfied that the matter of the appellant's knowledge in 3 is a matter which was the subject of final determination by the FTT. And then at 76, the appellant had the full opportunity to put forward its case as to the absence of connection to fraud and its want of knowledge of such connection. In short, the alignment with Hackett, it would be contrary to the principle of finality of litigation to allow the FTT's determination in 2017 to be revisited in this appeal. There are no circumstances which could justify such a course. And those decisions were either not then appealed to the Upper Tribunal or upheld by the Upper Tribunal. And that same principle was applied in this case of trees. So I appreciate there still is the Johnson versus Gorwood test to be applied, but that is the rough framework of which the FTT has currently been operating under for the last few years. And so with respect to this category of cases where it is deemed to be an abuse to relitigate the underlying liability, the burden will inevitably, as far as the penalty is concerned, have been on the taxpayer because it's passporting the liability finding from the earlier tax liability appeal where the burden was on the taxpayer. So in this category of case of penalty, burden is on the taxpayer. And in my skeleton, I undertook some, I don't suggest this is a definitive analysis, but in 2024 there were 23 VAT penalty cases according to Bailey, and this scenario arose in 2 of those 23. The second category of proceedings I will badge as concurrent proceedings, and I can take this a little bit more briefly. This would be the scenario where a tax liability appeal and a penalty appeal, that penalty appeal flowing from the tax liability, are heard during the same hearing, So HMRC issues the penalty and personal liability notice roughly at the same time as the underlying tax assessment. And in that scenario, the usual procedure, if not the one that is always followed, is that the question of the underlying tax liability is determined first in time by the FTT in its decision, with the burden being on the taxpayer unless one of those exceptions applies. And then you see a decision coming to a finding with respect of the question of underlying liability, and then assuming it's in HMRC's favour and the appeal has been dismissed, that finding passports forward to the penalty, and then the tribunal just goes to consider the bespoke penalty elements, such as amount, whether there's any culpability condition or not. So again, in that scenario, which I'll badge as concurrent proceedings, again, the burden has been on the taxpayer unless one of the exceptions applies. I won't take when we go through some cases later on, we'll see that in practice. I won't take any examples of that now. Of my rough and ready analysis, that scenario in 2024, that was 12 of the 23 cases. And as we'll come on to when I make submissions on ground 2, that's what we say should have happened with respect of in ground 2 with respect of the underlying liability to be registered. That should have been dealt with as a standalone tax appeal burden on the taxpayer, and that finding should have passported forward to the Schedule 41 company penalty and personal liability notice. But that, I'll make more submissions on that with respect of ground 2 in due course. The third scenario, which is the one which also featured in this case, was one that I will badge as the penalty alone scenario. And this is where there is a penalty appeal, but there has not been previously a judicial determination with respect of the underlying tax liability. Now, that could be for various reasons. It could be that there was an appeal with the underlying tax liability and that was withdrawn or struck out for whatever reason. It could be, as frequently happens, and increasingly so, that some of the companies they initially make an appeal, they then go into liquidation, and the administrator takes over and then pulls the company appeals. But of course, the director who has a personal liability notice issued on him still understandably wants to pursue the appeals. Or it could happen, as we see in this case, because with respect of some forms of appeal under Section 83 of the VAT Act, which sets out all the different elements of appeal, some of those, there is a requirement that the money be paid on account before you can appeal, unless you can show hardship. And so a taxpayer might not be able to show hardship, doesn't pay the money onto account, therefore they can't appeal, say, the underlying assessment. But that hardship provision doesn't apply to penalties or personal liability notices. So there's no requirement they pay the money onto account, so they still appeal that. And again, then there's the question: the underlying liability hasn't been determined. Now, for all the same reasons, we're then in a Johnson and Gorwood broad merits-based test. But as I alluded to when I went through the earlier cases, the almost general rule of thumb now in the FTT is that in that scenario it is deemed as fair that you let the taxpayer mitigate the underlying tax liability that hasn't previously reached judicial determination. And of course that was similar to the facts in the Kishaw Court of Appeal case, where that case had been struck out but not reached a final judicial determination. And it's in this scenario that the Upper Tribunal ruled in this case that the burden, when we're in this third scenario, that the burden should be on HMRC with respect of the underlying question of liability, departing from, and we'll come to it in due course, another Upper Tribunal decision in the case of Zahn. So HMRC's obvious point with respect to that is there is a significant inconsistency as to where the burden falls in relation to those different scenarios. and the burden, and then there needs to be consistency, we submit. From my rough and ready analysis, that scenario happened in 9 of the 23 cases in 2024. So I slightly take issue with the Upper Tribunal's permission to appeal remark that it doesn't happen that often. It happened on that analysis on 39% of the cases. And just to highlight the point that the Upper Tribunal were making this distinction between this category of cases and, say, the concurrent category of cases, if I could just turn to the Upper Tribunal's permission to appeal decision, which can be found in the core bundle tab 6, page 145. And it's at paragraph 11.1. Five lines down, in granting permission to appeal, the Upper Tribunal said this, so 5 lines down in 11.1, as noted in the decision at paragraphs 105 to 107, in the normal case, the assessment of the underlying liability and penalty will be determined as part of the same proceedings, applying the general rule as the burden of proof to which the decision refers. In practice, the decision is only likely to have material effect in a limited number of cases where the appeal is against the penalty alone in circumstances, as also occurred in Zaman, where the underlying liability has not been determined by the courts or tribunals or by agreement, and questions of abuse of process or issue estoppel do not arise. So therefore, the Upper Tribunal was clearly seeing, according to its permission to appeal, a distinction between this third category and the earlier 2 categories as to the burden. So I now turn, if I may, to ground 1. Ground 1 is that the Upper Tribunal erred in law in saying the burden of proof fell on HMRC with respect to all relevant aspects of the penalty appeal, save for quantum. HMRC's submission is that where a taxpayer challenges a Schedule 24 or 41 penalty assessment on the grounds that the underlying tax liability is wrong, save for the exceptions we've already outlined, the burden of proof remains on the taxpayer with respect to that underlying tax liability component of the penalty. Our submissions with respect to ground 1 can be broken down into 2 sections, 2 halves. The first half is to say that it is possible to separate those parts of the penalty proceedings which determine a criminal charge from those parts which do not. And if that is the case, and Article 6 doesn't apply to the tax liability component because it is possible to separate, then it was the Article 6, which was the main reason we say why the UT decided the burden was on HMRC. And so if it is possible to separate, we say the burden can remain as it usually is, and as Feranzi says it should be, on the taxpayer. The second half of our submissions is in the alternative. If it's not possible to separate out the proceedings such that the entirety of the penalty proceedings engage Article 6, then the burden still being on the taxpayer with respect to the liability aspect only is nevertheless still compatible with Article 6, or does not unjustly infringe the presumption of innocence, or is within reasonable limits. The test slightly varies from the different cases, but the thrust is clear that it's still Article 6 compatible. So I now turn to make submissions on the first half of those ground 1 submissions, that it is possible to separate out the proceedings. And I first am going to go to the ECHR case law with respect to this. The first case I'm going to go to is Gisela versus Finland. This can be found in the Authorities Bundle, Volume 2, Tab 20, page 323. By brief overview of the facts, Gisela versus Finland related to a car repair shop. There have been errors and deficiencies in its accounts. The government of Finland issues assessment and surcharges, which is the often the name for penalties on the continent. In this case, the surcharge was for €300. No oral hearing was allowed, and the taxpayer argued a breach of Article 6. And the issue arose during these proceedings as to whether the proceedings were indeed criminal proceedings for the purpose of Article 6. However, the court gave this principle, or repeated this principle, and we can see this at page 333. At paragraph 45. While the court has found that Article 6 of the Convention extends to tax surcharge proceedings, that provision does not apply to dispute over the tax itself. Quoting Ferenczi. It is, however, not uncommon for procedures to combine the varying elements, and it may not be possible to separate those parts of the proceedings which determine a criminal charge from those parts which do not. The court must accordingly consider the proceedings in issue to the extent to which they determined a criminal charge against the applicant, although that consideration will necessarily involve the pure tax assessment to a certain extent. And I'll come back to the reference to a certain extent in due course. But in my submission, what can be taken from that guidance is a question, is it possible to separate the proceedings? It may not be possible to separate those proceedings. So the question I suggest this court needs to ask itself is it possible to separate the relevant proceedings that are before it, namely the Schedule 24 and Schedule 41 penalties? I also make the submission that that seems to be an objective test. Is it possible to separate? And we submit that the Upper Tribunal took a misstep in not applying itself to that question.
So, I mean, this is the Grand Chamber, so clearly an important part of the learning on this subject. And what it does clearly establish, I think you're telling us, is that there is no hard and fast rule saying that just because a penalty is involved, therefore Article 6 is inevitably in play in relation to all of the elements of the appeal.
Exactly. Yes.
I mean, if that had been the position, they would have said so. But
exactly.
Plainly, it is a much more, it's a more nuanced test that has to apply based on the possibility of severance.
Yes. Yes, and I'm going to come on to that point. It doesn't go that far, and we say the Upper Tribunal in this case has arguably gone further than any other ECHR or any other domestic authority. It's completely at one end of the spectrum, essentially saying that because the penalty depends upon the tax liability, Article 6 has to apply to the tax liability. Well, firstly, we say that's not what the guidance is from the Grand Chamber, and also we say there's an inherent inconsistency there with the first two scenarios that I've gone through.
And do we get any further help from the facts of this case, or not really?
No, I don't believe so. No, it was really just that principle that I was seeking to draw out.
And I dare say it doesn't help, but were they able to disentangle the issue in this case?
I think they said Article 6 did apply, but that there was no breach of Article 6 by the fact there couldn't be an oral hearing, is my understanding.
If I remember rightly, I mean, the reason the case was brought as a test case was because the amount of the penalty was actually very small, it's insignificant. And it was for that reason that it might have been, the temptation might have been to say, well, we can just ignore it.
Understandably, but that's where we can see the court has set the angle criteria arguably quite low in that regard.
Yes.
There are two other ECHR cases. And the other point I make this now is, of course, my learned friend may well say, well, these were concurrent proceedings and therefore seek to distinguish them from the penalty alone scenario. But my response to that is what the guidance here shows, that in principle and practice, it is possible to separate, or that same test. There is no reason in principle or practice why that same test should not be applied to the penalty alone scenario. And again, there are two further ECHR cases which I wish to draw the court's attention to, and they've both made it clear that, again, in the concurrent scenario, the concurrent existence of an assessment and a penalty surcharge does not bring the whole proceedings within the scope of Article 6. And so the first of those is the case of King, which can be found in the Authorities Bundle at Volume 2, tab 26, page 455.
So this is earlier.
This is earlier. It doesn't set out the same separation test, as it were, but it does reinforce the point in concurrent proceedings, as I'll come to in a moment, that Article 6 doesn't apply to the tax liability aspect. So this case, King versus United Kingdom, is actually a follow-on from the case of King versus Walden that my learned friend relies heavily upon in his submissions. And the brief factual overview is that there were underdeclared earnings from a guest house business. HMRC raised assessments, including for negligent or willful default, as some of the periods in question were over 6 years old. They also raised a penalty under Section 95 of the Taxes Management Act for fraudulent or negligent delivery of a return. It works its way up to the Grand Chamber, the taxpayer complaining that there has been a breach of the reasonable time requirement under Article 6. But the passage I wish to draw out is at page 464. And at the bottom of that page, just below H, the court's assessment, and this is bearing in mind that this is concurrent proceedings dealing with both an assessment and a penalty. The court would note, first of all, that the procedures concerning the assessment of tax owing by the applicant fall outside the scope of Article 6, as neither concerning the determination of a criminal charge or any of the applicant's civil rights or obligations, quoting Franzi. As, however, regards the imposition of penalties calculated as a percentage of the unpaid tax, the court considers that these cannot be regarded as pecuniary compensation for any costs that may have been incurred as a result of the taxpayer's conduct, but that the main purpose was to exert pressure on the taxpayer. And then it goes on. So the point I make here is clearly in concurrent proceedings, the court is clear that Article 6 doesn't apply to the tax liability component. And we see the same again in the case of Janovic versus Sweden, which can be found in the authorities bundle at volume 2, tab 30, page 523.
Yeah, we're back a bit further in time.
We are. Reverse chronological order, I'm afraid. And we see here at paragraph 8 a brief summary of the facts. This related to a taxi cab firm.
Sorry, paragraph 8 of the judgment.
Yes, so it appears at page 523.
Yeah.
And this is merely just to briefly explain the facts. Paragraph 8, we see that there's an investigation into a taxi cab firm tax audit. And then we see at paragraph 9, there are both then assessments and at the bottom of paragraph 9, surcharges amounting to 20% or 40% of the liability. So again, here we have concurrent proceedings. There were multiple issues in play in this case, including whether Article 6 applied to the penalty, access to justice, the length of the proceedings. The access to justice point was actually because, similar to the hardship provisions, there had been a requirement the amount paid be paid on accounts before they could pursue with the appeal. But for our purposes, if I could ask the court to go to page 541, and paragraph 64. Paragraph 64, the court has consistently held that generally tax disputes fall outside the scope of civil rights and obligations under Article 6 of the Convention, despite the pecuniary effects which they necessarily produce for the taxpayer. The facts of the present case do not give reason to review that conclusion. 65, having regard to the fact that the tax surcharges were imposed on the applicant, the question arises whether the proceedings in the present case instead involved a determination of a criminal charge, and then it goes on to determine the question of a criminal charge, and then it reaches its conclusion at para 71 on page 543. Paragraph 71. To sum up, the court concludes that the proceedings concerning the tax surcharges imposed on the applicant involved a determination of a criminal charge within the meaning of Article 6 of the Convention. This provision is therefore applicable to the present case. So therefore, those latter two authorities make it clear that in concurrent proceedings, Article 6 doesn't apply to the tax liability aspect.
Should we look at page 545? 579.
I'm grateful. Yes, so paragraph 79, in terms of the court assessment, it is further to be noted that the relevant domestic proceedings have concerned both taxes and surcharges. In the light of its conclusion that Article 6 does not apply to the dispute over the tax itself, the court will consider the proceedings to the extent to which they determine a criminal charge against the applicant, although that consideration will necessarily involve the pure tax assessment to a certain extent.
That looks very similar to what the Grand Chamber reiterated much later on in the Singh case.
Yes.
It may be very actually at its origin.
How does that play out?
There are various issues in play in terms of access to the court because of the equivalent of paying the amount into account. So from recollection, with respect of all matters, and I stand to be corrected, there wasn't found to be a breach of Article 6 with respect to any of the complaints, but I would need to just double check that.
I see at the end of 95 it says there has been a breach in respect to the length of the proceedings.
I apologise.
And then they come on to presumption of innocence, which sounds more our territory.
Yes. Conclusion with relation to presumption of innocence. Yeah, at the on page 552, which is the conclusion with relation to presumption of innocence, there's accordingly been no breach of Article 6(1) and 2 in this respect.
That is right. On a quick look at this reasoning, that appears to be because it fell within the implied exception. They mention Salabia, in other words, that imposing the burden of proof on the taxpayer in this context was justified and therefore compatible.
Yes.
Not. I don't know. I haven't read this sufficiently fully. You may be able to help me. But are they saying that Article 6(2) doesn't apply at all to the tax assessment element of the penalty proceedings?
My understanding of it here is that they were saying that dealing with the presumption of innocence in this case, they were principally concerned with the point at paragraph 100 as to what the position was with respect of surcharges, penalties. Consequently, the starting point for the tax authority in court must be that inaccuracies found in tax assessments are due to an inexcusable act attributable to the taxpayer.
Sorry, where are you reading from?
Paragraph 100.
I see.
Consequently, the starting point for the tax authorities in court must be that inaccuracies found in tax assessments are due to an inexcusable act attributable to the taxpayer, and that it is not manifestly unreasonable to impose a tax surcharge as a penalty for that act.
It doesn't help that there are 2 paragraph 100s, but I'm on to the correct paragraph.
Yes, I know.
Well, 3 paragraph 100s, in fact.
But then it says the Swedish tax system thus operates with a presumption which is for the taxpayer to rebut. And then above that paragraph 100, it talks about the taxpayer being able to make out that it would be unreasonable to impose the penalty.
So here, this presumption isn't in relation to the underlying tax liability. It's going beyond that.
It's relating. It's in relation to the fact that it's almost carried forward for the point in principle that the underlying liability is carried forward for the surcharge or the penalty unless the taxpayer can show that it's unreasonable. And so I suppose you could say this is slightly analogous to,
Well, is that what 100 is saying? That seems to be saying, that seems to be worrying about whether the inaccuracies are due to an inexcusable act. And apparently there's a presumption under Swedish law of inexcusability.
Certainly the way I read, sorry.
I don't want to interrupt my learned friend's flow, but it's perhaps worth, while we're looking at this, look at paragraph 98.
Yeah.
All I was going to say, Mr. Hayes, but I may be wrong, is that it looks as if the analysis of the court is to assess the proportionality of the imposition of the burden of proof on the taxpayer.
yes,
At 101 they refer to Salabiaku, which is a classic authority on reverse burdens of proof. And at 102 they say, in assessing whether in the present case this principle of proportionality was observed, ... it may be that they just don't deal with the threshold question. That's because they didn't need to.
yes. I was certainly going to rely upon this case again when I come back to the second half of my
Understand.
submission on that point, to say that even if Article 6 can't be separated, that it is still consistent with Article 6 for the burden to be on the taxpayer. In line with that point.
Yeah. Speaking for myself only, I don't find the judgment entirely clear on whether it's actually addressing the first question, the threshold question,
Yes.
which you are
Yes.
addressing.
Yes.
I'm not sure it's against you, but it might be said it's not in your favour either.
Yes.
Because I must say that there isn't a bit that jumps out at you that's addressing the threshold question.
I accept that.
Yeah.
If I can then turn to the domestic authorities on the question of separation. And the first I wish to go through is the, hopefully now in chronological order, is the case of Omar Minerals. This is an FTT decision, and it can be found in one of the authorities under tab 18, and page 241. Here, HMRC had assessed Omar Minerals in respect to the arrears for aggregates levy and also charged a penalty. You see that in paragraph 1. So these were concurrent proceedings, I accept that. Paragraph 3, this decision relates to a preliminary issue which the parties have asked me to determine. The hearing of the substantive issue in relation to the assessment to aggregates levy and the related penalty remains to be concluded. The preliminary issue relates to the question whether the proceedings before me constitute proceedings of a criminal nature, such that the provisions of Article 6 of the Convention apply. Para 4, the parties produced helpful written submissions on this issue. After considering those submissions, I asked the parties to consider how Article 6 would apply if, in relation to the assessment, I decided that the proceedings in relation to the assessment were not within Article 6, e.g. applying for ANSI below, but that in relation to the penalty, the proceedings did relate to a criminal charge. I drew the parties' attention to the submissions of Mr O'Donoghue, which argued without referring to authority, that Article 6 would apply to the whole proceedings because they were criminal in nature. The parties then produced further informative written submissions for which I am grateful. And then in relation to HMRC's submissions in relation to that, if we go to page 250, paragraphs 31 to 33. In his further written submissions, Dr. McNall argued that even if the penalty was a criminal charge, that did not mean that the proceedings in relation to the assessment were criminal proceedings for the purpose of Article 6. The assessment, Dr. McNall observed, was not dependent on the penalty. The law, facts and matters relating to the assessment remained the same irrespective of whether the penalty was charged or not. Dr. McNall accepted that if the assessment was displaced, then the penalty fell with it, but not vice versa. The underlying position was that challenges to an assessment did not engage Article 6 for ANSI. There was no reason why the underlying Article 6 position as regards the assessment should be changed by the issue of a penalty. Then at paragraph 40 on page 252, at the very top of 252, we can see the FTT considers that passage of separation from Gisela that I went to before. Before then, going to give this finding at 256, starting at paragraph 54. If the penalty is a criminal charge, are the entire proceedings criminal in nature? 54. The next question is whether the assessment and penalty proceedings should be viewed as a whole and whether the protections of Article 6 in relation to the criminal charge could be applied to the entire proceedings before me. I've come to the conclusion that Article 6 does not apply to the whole of the proceedings and is engaged only as regards that part of the proceedings which involves the penalty. In this case, as Dr. McNall observed, the assessment is not conditional upon the penalty. The assessment is a purely conventional procedure to determine the liability of a taxpayer to tax, in this case aggregates levy, for certain specified periods. Applying for ANSI, I consider that I am bound to hold the assessment does not engage the criminal head, or indeed any head of Article 6. That conclusion, in my judgment, is not affected by the penalty. That the penalty is contingent upon the assessment being upheld is clear enough. Paragraph 9(1)(a) of Schedule 6 of the Finance Act 2001 requires HMRC to show that the appellant's return has understated its liability to aggregates levy. But HMRC does this, in my view, by relying on the determination of the appeal in relation to the assessment proceedings, which are outside the scope of Article 6. If the appeal in relation to the assessment is determined in HMRC's favour, HMRC can rely on this fact in relation to paragraph 9(1)(a). HMRC must, however, show that the penalty has been correctly calculated. So I just pause there. What I'm saying is this is consistent with the approach that we're advocating with respect to Schedules 24 and 41, whereas the burden with underlying liability is on the taxpayer, but with respect to bespoke penalty matters, whether that be culpability or calculation of the penalty, the burden's on HMRC. I carry on. Paragraph 9(4) then places the burden of proof on the appellant to show that there was a reasonable excuse for its conduct. The determination of the assessment appeal is the preliminary issue in dispute, and the penalty appeal is subsidiary to and contingent upon that preliminary issue. Usually, the burden of proof falls on the taxpayer to displace an assessment. See, for example, Brady. There is good reason for this rule. In most cases, the facts relevant to liability to tax will be within the knowledge of the taxpayer, or at least the taxpayer would be better placed to produce evidence of the underlying facts, documents, witnesses. I would be loath to disturb such a well-established rule, one which in my view is eminently sensible, by holding the criminal head of Article 6 applied to assessments as well as penalty proceedings whenever an assessment appeal are heard with penalty appeals. Furthermore, whilst the UK assessment and penalty proceedings are often heard together, this is not the case in every signatory state. It would be odd, therefore, if the application of Article 6 to an assessment appeal depended fortuitously on whether an assessment appeal was heard separately or together with a penalty appeal. So that's my consistency point. This would be a strange conclusion, which of itself suggests that Mr. O'Donoghue's argument cannot be correct. 62. I accept, however, there may be cases, as the court observed in Giorgio, where the instance of liability in respect of a penalty is so intimately linked to the manner in which the substantive liability tax arose that the two proceedings cannot be separated, and that consequently the consideration of the proceedings in relation to a criminal charge must to some extent involve consideration of the substantive tax assessment. Thus in Giorgio, the penalty proceedings required a finding of dishonesty after the consideration of extensive evidence at the hearing spanning 49 days, evidence which related to the assessment and the penalty. In that context, the court's observations concerning the difficulty of separating the proceedings were entirely understandable. This appeal is very different. Here, the main issue is whether the rock extracted by the appellant was exempt from aggregates levy. That is the main issue in the assessment appeal. The penalty is contingent upon the answer to that question, but is a separate issue. I see no difficulty in separating the proceedings as regards the application of Article 6. I therefore determine the preliminary issue as follows. The assessment does not engage Article 6. The penalty is a criminal charge for the purpose of Article 6. Article 6 does not apply to the whole of the proceedings, but applies only to proceedings in relation to the penalty. So two points there. We say the Schedule 24 and 41 penalty framework is very similar to that was before Omar, and it's entirely possible for a separation to take place. And after I've finished going through the domestic authorities, I'm going to take the court through the particular provisions to show how separation is possible. With respect of the reference to the case of Giorgio, in due course I was going to come to that and take the court through it and explain why in that case, which related to a dishonesty underlying liability aspect, it was much more challenging to undertake separation. But in relation to Schedule 24 and 41 penalties, in this matter, there is no dishonesty allegation within the underlying conditions of either of the penalty.
Do you accept that this is a case falling into your category of concurrent proceedings?
This case falls into both.
Oh, okay.
Because we've got my ground 2 point relates to the fact that I've got concurrent.
Yes.
But I've also got penalty alone,
Yes.
in terms of, say, the excise assessment as well. And one of my submissions later on is just as to the complete unworkability, we say, of the Upper Tribunal's framework. Because what happens when you have, say, concurrent VAT proceedings, where ordinarily the underlying liability, the burden will be on the taxpayer, heard alongside penalty alone excise proceedings, where according to the UT decision the burden is on HMRC. But what happens is they all depend upon the place of supply, the very same issue. Is that issue determined twice? Once in the context of the VAT proceedings, concurrent ones where the burden is on the taxpayer, and again in the penalty alone scenario, it simply doesn't work as an overall architecture. There cannot be consistency.
And I understand that's one of your submissions, that if you like, that's to do with practical workability. But if I've understood the submission correctly, based on this authority, the reasoning of paragraphs 54 to 64, which you've just shown us, I don't think that's actually addressing practical difficulties. It's making a more fundamental point of principle, which is that what matters is not a temporal concurrence, but whether there is analytically a conceptual possibility of separating the two elements. And the judge here, right or wrong, appears to be saying that I can separate the relevant issues and then proceeds to decide on that basis. You would commend this reasoning to us.
Yes, so I accept these are concurrent, which is the point my learned friend makes, but the point of principle and the approach and all the reasoning can equally apply to penalty lane scenario.
I'm not saying you're right, but that is how I understand the judge is expressing his reasoning.
If I can now turn to the case of, I note the time. Is the court happy to carry on sitting through? Or?
Yes, we haven't got a transcript, have we? No. We'll just sit through to 1 o'clock.
I'm going to turn to the Upper Tribunal decision in Zaman, which is a penalty alone scenario. So this can be found in the Authorities Bundle at Volume 1, Tab 17, page 232. Paragraph 2 makes clear that Mr. Zaman appealed against a personal liability notice. But para 3 makes clear he did not appeal the underlying assessment, or indeed paragraph 4 appealed the underlying company penalty. This was a Schedule 24 penalty, personal liability notice, similar to one of the personal liability notices we had in this case. Paragraph 6 is a recitation of the agreed issues before the tribunal, and they're in fact very similar to the issues in this case. Point 1, whether Zamco, which was the company which the personal liability notice related to, whether Zamco's VAT returns in the relevant period contained inaccuracies amounting or leading to an understatement of liability to VAT, the inaccuracy issue. The issue is essentially whether all of Zamco's supplies in the relevant period were in the UK for VAT purposes. If so, its VAT returns contained such inaccuracies. If not, they did not. And then we go on at paragraph 8 on the following page. The FTT identified the evidence to be considered in determining the place of supply of Zamco's alcohol sales for VAT purposes, including Mr. Zaman's evidence that the goods were in the warehouses in France and Germany at the point of sale. So we're dealing with an incredibly similar factual scenario as we were in this case. Mr. Malde's position was, I'm not in control of these companies and I can't answer anything about where the supplies took place. But the secondary point, as it were, and I'll take you to my learned friend's closing submissions, was that we're putting forward the fact that the supplies, or positing the fact that the supplies could have taken place on the continent, not in the UK. So it's very similar in factual scenario to the matter before us. Paragraph 10, the Upper Tribunal notes the FTT found Mr. Zaman's evidence was inconsistent. And then at 13, the FTT's conclusion summarised. We thus find that it has not been proven on the balance of probabilities that the alcohol goods in question were removed to the UK by Zamco or under its directions. And so for the same reasons, it is not proof that the place supply of all Zamco supplies in the relevant period was the UK, such that its VAT returns in that period contain inaccuracies. Given the burden of proof on HMRC, this means we have to allow the appeal, and strictly speaking, need not consider the other issues in this appeal. So there, like the FTT in this case, they found the burden with respect of the underlying tax liability, which was the place of supply issue, was on HMRC. We then go forward to paragraph 17, where the Upper Tribunal cites the case of awards drinks. It goes through the principles, it goes through at 19, quotes a passage from awards drinks, including quoting their Lord Justice Khan Worth in Khan, before paragraph 20, saying it's therefore well established law that on an appeal from an assessment to VAT, the assessment stands good unless the appellant is able to produce evidence to show that it is wrong. And then here is HMRC's key argument, which the Upper Tribunal then adopts. 21. HMRC have always maintained they bore the burden of proof in relation to the validity of issuing the PLN. They also accept that Mr Zaman could appeal the PLN on the basis that the underlying assessment and penalty were wrongfully issued. So that's the Johnson and Gorwood point that hadn't previously been decided. However, HMRC submitted that the FTT erred in its failure to apply a shift in the evidential onus of proof in circumstances where Mr Zaman positively asserted that before the FTT that there were no vatable supplies. At that point, HMRC submitted, Mr Zaman assumed the evidential burden of displacing the assessment. And if he failed to discharge the evidential burden, the penalty would accordingly stand. The challenging of the VAT assessment in the context and appeal against the PLN did not, and sensibly could not, affect the applicability of the PLN proceedings to the rules governing the way in which assessments to VAT are challenged. Whether an assessment to VAT was challenged directly, which we note above did not happen in this case, as Zamco brought no such appeal, or whether it was challenged as a defence to bringing a penalty proceedings relating to the original assessment, could not affect who bears the evidential proof in relation to any challenge brought to the VAT assessment. 23. HMRC submit that the FTT erred in treating the appeal as a penalty appeal in which the legal and evidential burden of proof remained with HMRC throughout in relation to all underlying issues. Once Mr Zaman challenged the issuing of the PLN on the sole ground that the assessment to VAT on Zamco was wrong, the FTT should have approached the appeal by considering firstly whether HMRC had established that the PLN was validly issued, and if that burden was discharged, by then considering whether Mr Zaman had established that the assessment to VAT on Zamco was wrong. In relation to that latter issue, his evidential burden was on Mr Zaman to establish that the assessment should be discharged in the same way it would have been on Zamco to establish that it had been overcharged by the assessment if it had decided to bring an appeal against the assessment.
Can I just ask you about that passage, paragraphs 22 and 23, which is a summary of HMRC submissions in that case?
Yes.
But it starts talking about legal and evidential burdens, and indeed seems to be largely framed in terms of a shift in the evidential burden. I may be wrong, so please correct me if I am, but in the present appeal, is it your submission that it's nothing to do with the evidential burden, it's everything to do with the legal burden, and that in a penalty case, the legal burden of proof rests on the taxpayer?
With respect to the underlying liability aspect.
Yes.
Yes, I mean, with respect to all other aspects, I mean, I would respectfully suggest that there's a slight confusion there in the terminology of evidential and legal, but as we'll come on to in a minute, the thrust of what they meant is pretty much the same thrust as I'm advocating for now, is that essentially when a penalty is issued, the burden with respect of all bespoke, whether was it issued properly, the culpability conditions, the amount, all bespoke penalty elements falls on HMRC. The legal burden with respect of the underlying liability falls upon the taxpayer.
Yeah. So in a nutshell, but I don't want to put words in your mouth at all, so correct me if I'm misunderstood, but in the present appeal, whoever's right, the issue that we are concerned with on this appeal concerns where does the legal burden of proof rest, and evidential burden is nothing to do with this case.
Yes, yes, I suggest that is just a confusion of terminology here. And then we see the FTT's reasoning at paragraph 33. It quotes the FTT. As this is a penalty appeal, HMRC the burden of proof to show that the PLN was validly issued. The standard of proof is the ordinary civil standard, being the balanced probabilities. However, in our judgment, HMRC are plainly right that as per their submissions we have set out above, if the challenge to the PLN was brought on the basis the assessment to VAT on Zamco was wrong, the legal rules relating to the way in which the assessment could have been challenged by Zamco, if it had appealed the assessment, remain in play in any appeal against the PLN. And that possibly just deals with a reference there to the legal rules. As we set out above, it is well established law that it is for the taxpayer to prove by evidence that an assessment to VAT issued by HMRC is incorrect. HMRC do not have the evidential burden, and that cannot sensibly be affected by the fact that the challenge to the assessment occurs in satellite litigation where, as in this case, a penalty charge on Mr Zamco is sought to be defended on the basis the assessment of VAT on Zamco was wrong. In our judgment, it is clear that the FTT lost sight of the fact that after establishing whether the PLN was validly issued, the evidential burden in relation to the assessment of VAT on Zamco shifted to Mr Zaman when he sought to positively challenge the assessment as a sole basis on which the PLN was invalidly issued.
This is why I asked the question I did a moment ago, because I'm afraid, with all due respect to the Upper Tribunal, they do appear to be falling into confusion here as between the legal burden of proof and the evidential burden. And and sometimes in the authorities we do see reference to evidential burden shifting during the course of a trial. But I think that your submission in the present appeal is that we're concerned with the legal burden.
Yes.
And references to evidential burden are irrelevant and perhaps act to confuse.
Very much so, yes.
We actually have to, in Brady, which is one of the cases referred to, Lord Justice Mustill, rubbishing evidential burdens.
Yes. So just to conclude, see the FTT's overall conclusion at 96 as to whether HMRC had discharged the burden of proof, and then it quotes the FTT 35. Read together with the FTT's other findings, we consider that 96 discloses an error of law in relation to the burden of proof. We also consider that this affected the way in which the FTT approached the appeal against the PLN in a materially relevant way.
So in effect, what you're saying is where they keep referring to evidential burdens, they mean legal burdens.
Yes. I mean, I think I highlighted as well at some stage earlier on in that passage, they did refer to legal as well.
Yes, of course, in the word legal from time to time, just as a sort of reminder.
But putting that aside, if we understand that just to be a confusion as to terminology, which I say it is, we say the reasoning is otherwise sound. And And I'm now going to turn, just before finishing this section, to 3 FTT cases that followed Zaman and applied it. I'm just going to very briefly jog through them.
Because are they really going to help us?
Well, only,
I mean, we're not bound by the Upper Tribunal, let alone by the first tier tribunal.
only to say that it very much shows separation is possible, because that was, so in that case I needn't, but my point on them is that it shows separation is clearly possible because it was repeatedly applied.
Well, perhaps take us to the best from your point of view, where you get something most similar to this case.
In that case, then, I will take you to the case of Nassim Dost in volume.
I think that must be volume 2 as well.
Yeah, no, the volume 2, tab 24, page 406. So we see here, this is the appeal against the personal liability notice under, and we see at paragraph 4, this relates to Schedule 24 of the Finance Act. The same provision we have here. At paragraph 9, scrolling down, we've got the point, as we say, the correct application is that with respect to the bespoke penalty elements, such as the culpability condition of deliberate behaviour, we see at paragraph 9 the burden of proof is on HMRC. But at the same time, this is Judge Chapman, King's Counsel, at paragraph 12. We see them quoting and upholding the case of Zaman, making a point of consistency that I've otherwise made. Paragraph 12, the officer cannot be placed in a better position than the company when challenging such an assessment. And so the burden lies upon the officer to establish that the assessment is incorrect. And then it goes on to quote Zaman. So that's the FTT drawing out the consistency point, again, in a penalty alone personal liability notice scenario. The other cases I've referred to in my skeleton, and so needn't take the court to.
Sorry, could you just give me the reference on the skeleton?
I can, or the reference is the case of Arizo, which is in volume 2 of the Authorities Bundle, tab 23, pages 383, 397. And we say that case is noteworthy because it was actually Judge Brooks who was the first tier judge in this case. But of course, Zaman, the chronology is, I think Zaman was just released prior to his decision, his FTT decision in this case. And then the third...
Sorry, prior to his FTT decision in ISO Associates.
No, in the FTT decision in this case, saying that the burden fell upon HMRC, in Judge Brooks's 2022 FTT decision in this case, which I think came out in October.
Yeah, do you know, I hadn't sort of woken up to the fact that the FTT decision in this case predates the 2023 decision.
I think what had happened was if I check the helpful chronology you asked us to provide.
Right, so this is October 22, our case.
Yes, our case is October 22. But Zaman was released a couple of weeks beforehand on the 16th of September, but that was after submissions had finished. And so clearly Judge Brooks wasn't aware of it.
when deciding the
when
FTT
deciding this
decision in
case.
this case.
But then fast forward to on that schedule 29th of June 2023, this case of Arizio, which I've just given the reference for, that's Judge Brooks then applying the Zaman principle.
Paragraph 49. 397.
Yes. Let me just check. Yes.
Yes, I'm afraid that the phrase evidential has crept into this, but not surprisingly, because it's applying Zaman. But if one were to delete the word evidential and insert the word legal, you would be content.
Yes.
In that case, there's no reference to this one.
No. Not I'm aware of. And I've now lost track. Have I given the reference to the case of Gopal, which is the third case?
No.
So that's in volume 2, tab 25, page 430, 431, 432.
So not surprisingly, the FTT regards itself as bound by the Upper Tribunal's decision in Zaman.
Yes.
You were going to bring out the extent to which one or more of these cases showed it being possible to separate the issues.
Well, in essence, that's what happened in all three of them.
Yes, I see.
The point is that they proceeded on the Zaman approach, leaving aside the confusion as to evidential and legal. They proceeded on that exact approach of burden being upon the taxpayer with respect of the assessment aspect, but on HMRC with respect of the bespoke culpability aspects. And on the first case I took you to is Nazim Dost. I showed you there in relation to the deliberateness, the culpability aspect, the tribunal clearly saying the burden's on HMRC with respect to that matter.
Yes,
So
yes.
the point it isn't just to regurgitate FTT authorities, the point is to say it clearly demonstrates consistently there is not a conceptual problem with separation.
Yeah.
I now seek to turn to going through briefly Schedule 41 and Schedule 24 to show why and how separation is possible, just the mechanics of those different. So Schedule 41 is in Volume 1, tab 14, page 175. This is Schedule 41, paragraph 1. A penalty is payable by a person P where P fails to comply with an obligation specified in the table below. And then at the bottom of that page, you've got the obligations under the VAT Act to failure to notify and register. So that is a straightforward passporting through of underlying liability. Page 184, you've got the excise provision under Schedule 41. A penalty is paid, this is section 4, a penalty is payable where a person P, where after the excise duty point for any goods which are chargeable with duty of excise, P acquires possession of the goods or is concerned in carrying, removing, depositing, keeping, or otherwise dealing with the goods, and B, at the time when P acquires possession of the goods or is so concerned, a payment of duty on the goods is outstanding and has not been deferred. Again, in my respectful submission, that directly mirrors an underlying duty points assessment. And in due course, when I'm going through the case of Euro wines, which is one of the cases my learned friend refers to, I'll elaborate on that in a little bit more detail. But essentially, again, that's just a simple passporting forward of liability. But then, with respect to the bespoke culpability conditions, we see these at paragraph 5. A failure by P to comply with the relevant obligations is deliberate and concealed, deliberate but not concealed, etc. So my submission is that with respect to the paragraph 1 and the paragraph 4 matters that directly relate to liability, burden on taxpayer, it's a passporting through of what would otherwise be the underlying assessment. Bespoke culpability conditions, section 5, such as deliberate and concealed, deliberate but not concealed, burden on HMRC.
Now, have you joined the dots for us? This tells us when a failure to comply with an obligation is deliberate and concealed. Where do we find something saying that that's crucial to the imposition of a penalty?
The following page indicates that at paragraph 6, where it sets out the different categories for which a penalty has to be in to specify the amounts.
So the actual basic charge, we have to go back to paragraph 1 right at the beginning.
Well, that is for the underlying liability. Then there has to be at section 5 with respect to a bespoke penalty, a determination of what the culpability assessment is, and then depending upon that culpability assessment, that then sets the parameters at paragraph 6 for the.
So 6 says this paragraph sets out the penalty payable under paragraph 1. And then
So
you
1
get
and 6 are the charging provisions. With the definitions in 5.
Yes.
so just to be clear, if you have something that is deliberate and isn't deliberate and isn't concealed, if it's in category 1, you're still liable to a penalty of 30%, if I've understood paragraph 2 correctly. Then, in that case, on your submissions, does the criminal, does HMRC bear the burden in relation to anything?
With respect of bespoke penalty.
Well, I haven't actually worked out what category 1 is, but we see there that if you look at subparagraph 2, if something is deliberate and concealed, there's such and such a penalty. If it's deliberate but not concealed, there's such and such a penalty. But for any other case, it's 30%. So is somebody liable to a penalty of 30% without the revenue having to prove anything really? It's sufficient that the taxpayer hasn't proved that there was no liability.
Well, there would still be, in the similar to, say, Omar Minerals or Zaman, HMRC would still have to prove that the penalty was properly issued.
So it's a formal requirement.
The formal requirement. It's set in Omar Minerals, it made the point that you've calculated it correctly, so we'd have to prove that we're within the 30% figure is made out.
And you have to establish the failure to comply.
Yes, but with respect of, I was going to come on to in a minute, but it's not the case that it's automatic that if you are liable for underlying tax, the penalty automatically follows, because there is a reasonable excuse provision within Schedule 41. And that can be seen at page 216. Section 20. Liability to a penalty under paragraphs 1, 2, 3 and 4 does not arise in relation to an act and failure which is not deliberate. So this would be in that third category. If P satisfies HMRC, so the burden being on P, or on an appeal to the tribunal, that there is a reasonable excuse for the act or failure.
So in this hypothetical case where the revenue aren't alleging deliberateness or concealment, the taxpayer is liable for the penalty, provided the revenue have complied with the formal requirements, unless the taxpayer shows that the tax was not due, or unless the taxpayer shows that there was a reasonable excuse.
Yes.
Yeah.
But even in that scenario, there would still be the formal requirement burden on HMRC. And then a similar argument can be made with Schedule 24, which we can see at Volume 1, Tab 13, at page 96. So this is the penalty regime in relation to inaccuracies. Paragraph 1.1, a penalty is payable by a person where P gives HMRC a document of a kind listed in the table below, which includes, say, a VAT return. Conditions 1 and 2 are satisfied. Condition 1 is that the document contains inaccuracy, which leads to an understatement of liability to tax, a false inflated statement, a false or inflated claim to repayment of tax. Condition 2 is that the inaccuracy was careless or deliberate. So HMRC's submission with respect to Schedule 24 is that the burden with respect of Condition 1 falls upon the taxpayer, because that's a passporting through of the underlying liability. But with respect of Condition 2, that the burden is on HMRC with respect to the culpability aspect. And again there, with respect to Condition 2, we see that, of course, non-careless behaviour wouldn't fall within the ambit of the penalty.
Yes.
And so again, under both provisions, it doesn't automatically follow that because you're liable to tax by way of, say, the underlying assessment, that a penalty necessarily follows. And so we rely upon that to say there is a clear dividing line between assessments and penalties.
But here, on any view, the revenue have to prove more than the formal requirements. Yeah.
So, turning back to the UT decision itself, and just to highlight one of their findings in core bundle tab 6, page 109. And paragraph 131, just to highlight one of the pieces of reasoning of the Upper Tribunal. At 131, there's the passage I've already read out, and then the Upper Tribunal says 4 lines down, we should only depart from a rule where there's a justified and proportionate exception to presumption can be justified on the facts and circumstances of the case. And then it lists its reasoning for why it doesn't think those apply in this case. And then the first reasoning, the penalties in this case were not of a regulatory nature. I'll come back to that point a bit later, but the point I make here, they are substantial penalties that are only payable if it is shown there has been a deliberate conduct on the part of Global and or Mr Malde that has caused a loss of tax. Well, we say that logic is flawed because we accept that with respect of the culpability conditions, the burden is on HMRC. The point in Zaman, we respectfully submit, is that the flip of the burden onto the tax, or the burden being on the taxpayer, just related to the tax liability aspect. So we say that the first principal point they make is significantly undermined by the fact that we accept, and again that was clear from that case of Nasendorse that I went to, that HMRC accepting that the burden for the deliberacy fell on them. My lords, I'm now going to go through 4 arguments, as I understand my learned friend make.
Are you going to return to the other subparagraphs in 131?
Yes, yes. Yes. I'm now going to turn to, as I've badged it, counter arguments. 4 arguments made by my learned friends and what our reply is to them. The first argument that they make, and that indeed the UT made to an extent, was that the underlying tax liabilities are integral to the penalties, and the penalties rely or depend upon them. So Article 6 should apply to all relevant aspects of the penalty. Our response to that is as follows. Many tax penalties depend upon an underlying liability which is integral to it. And so on that argument, it would never be appropriate to separate out the tax liability and penalty conditions. But we know that's not the case because Drusilla tells us that separation is appropriate where it is objectively possible. There is also the point that, my lords, you've already made, that Drusilla did not go as far as to say that because penalties depend upon underlying tax assessments for their underlying validity, Article 6 necessarily applies to the entirety of the proceedings. Drusilla didn't go that far. There is also the point that separation clearly happens in concurrent proceedings, and so clearly is possible by way of analogy. And we suggest the taxpayer's analysis fails to answer the question, why are tax liabilities integral to penalties in the penalty alone scenario, such as to activate Article 6, but not integral in the first 2 scenarios? The second point put forward by my learned friends is to say that because this case involved smuggling, inward diversion fraud, the resolution of the underlying tax appeal automatically or necessarily disposed of both the tax liability aspect and the penalty culpability element. We don't accept that submission. because even if HMRC are alleging this was a fraud or a smuggling operation, it does not mean that the underlying liability to tax depends upon that fraud. For all the same reasons, and I'll come to a pattern in a minute, the Court of Appeal was setting out in awards. The underlying question of liability depends upon, with respect to the tax assessment, whether a trader traded over the VAT threshold without telling HMRC they should be registered and accounting for VAT, and the underlying tax liability with respect to the excise, depending on whether they held goods in the United Kingdom where duty had not been paid. Neither of those determinations depend or involve a finding or a decision on fraud or dishonesty. And HMRC's position in this case was that it would have been wholly artificial not to call a spade a spade. In our case, it was a smuggling operation. I mean, that's what it was. So, and it was the badge or the name for this is inward diversion fraud, but that doesn't affect or mean that the underlying liabilities to tax depended on or revolved around fraud. And we also point out that the FTT could well make a finding, could very easily make a finding as to liability to tax without making any findings on fraud or not. They could just simply come to the conclusion, well, we think you've held goods without paying duty, or we think you've traded over the VAT threshold. And if, as HMRC suggests, the burden is on the taxpayer with respect to those questions, the tribunal could just simply come to the question to say to the taxpayer, you haven't proved your case. It does not require a finding of fraud or dishonesty. And in relation to that, I draw analogy to the reasoning that appears in the Court of Appeal case of awards from Lord Justice Mustill in Brady. And if I could take the court to the hard copy of awards and paragraph 34. This is Lord Justice Mustill in Brady. It may well be that if the taxpayer company's version does not correspond with the true facts, it must follow that someone was guilty of fraud. This does not mean that by traversing the taxpayer company's case, the revenue have taken on the burden of proving fraud. Naturally, if they produce no cogent evidence or argument to cast doubt on the taxpayer company's case, the taxpayer companies will have a greater prospect of success. But this has nothing to do with the burden of proof, which remains on the taxpayer companies, because it is they who, on the law as it has stood for many years, are charged with the task of falsifying the assessment. The contention that by traversing the taxpayers' companies' versions, the revenue are implicitly setting out to prove a loss by fraud, overlooks the fact that, in order to make good their case, the revenue needs only produce a situation where the commissioners are left in doubt. In the world of fact, there may be only two possibilities, innocence or fraud. In the world of proof, there are three. Proof of one other possibility and a verdict of not proven. The latter will suffice so far as the revenue are concerned. And so I make that point by analogy. If we say that here that the burden is on the taxpayer, notwithstanding that the fact that HMRC may be alleging against a wider backdrop of inward diversion, fraud or smuggling, because essentially we have to, otherwise it'd be wholly artificial, that doesn't change the underlying tenets of the assessment, and it doesn't mean the tribunal needs to make a finding on those either. So it doesn't necessarily, going back to my learned friends point, it doesn't necessarily resolve the culpability elements. And I would also make the point that if an allegation of fraud doesn't impact on the burden with respect of an underlying liability, it shouldn't do either with respect of the underlying liability in a penalty alone scenario. And there inevitably will be some factual situations where, just by their very nature, depending on what is found, the tribunal, when it comes to consider the culpability conditions, has a more straightforward job or not. But that's just a product of the facts of any particular case. The burden is still on HMRC to establish those aspects. And the final point I make is that there will be some perversity if the law favoured the more blatant or brazen evader of tax, because the more blatant or brazen they were, HMRC is almost, otherwise it'd be artificial to say it was anything other than smuggling or inward diversion fraud. because it is that, and it's openly blatant and brazen, and HMRC calls it out for what it is, suddenly they have a preferential.
I'm not sure I follow that line. It might be said that the whole rationale of our criminal law is that where the state makes very serious allegations, the more serious the allegation made, the better the reason for putting the burden of proof on the state.
Yes, I suppose I'm making it in the context that the underlying liability assessment doesn't involve that.
Yes, I think that may be the better way of making that submission.
I won't push it.
I'm sure it's helpful to start talking about degrees of brazenness.
The third point I wish to come back to with respect of my learning friends' submissions is to deal with the case of Giorgio, which is the one quoted in Omar Minerals as being a case where separation was not possible. That can be found in volume 2, tab 22. Page 375. This was a case where there was a takeaway food shop under declaration of earnings. Assessments were levelled and a dishonest evasion penalty was also issued under what was then Section 13 of the Finance Act 1985. So the Section 60 then became the follow-on provision in identical terms. So essentially it was a dishonest evasion penalty. So the same really as the Section 60 penalty. And one of the issues in the case was with respect of whether the proceedings were criminal proceedings and the extent to which they all were criminal proceedings. And at page 383, just above G, the paragraph starting just above G, the court says this. Again, this is the Grand Chamber. As to whether the assessments themselves should be seen as criminal charges for the purpose of Article 6 guarantees, the applicants argue that since the penalty proceedings rely on the assessments for their validity, it would be wrong not to look at the proceedings as a whole. The court accepts that it is not possible, given the various matters which were being determined by the tribunal, to separate those parts of the proceedings which determined a criminal charge from those parts which did not. It will consider the proceedings to the extent to which they determined a criminal charge against the applicants, although that consideration will necessarily involve the pure tax assessment to a certain extent. So, two submissions here. The first point is to draw the distinction between what the taxpayer's argument was in the first part of the paragraph, that because penalty proceedings rely on assessments of their validity, it would be wrong not to look at the proceedings from whole. That's the taxpayer's argument. The court's finding, we respectfully submit, is that it doesn't go as far to adopt that argument, but what it says is that given the facts of this particular case, it's not possible to separate. And in support of that argument, I would say that if that taxpayer's argument in the first half of that paragraph was the ratio, was the core principle, we would expect to have seen that being cited in Jusilla afterwards. It wasn't. What was decided in Jusilla afterwards was, is it possible to separate or not? The second point I make is as to why it was not possible to separate in these in this case, is if we actually look at the wording of the relevant provision, which we see at 381. It's at the very bottom, actually, as you can really see at the top of 382. Here we're dealing with a penalty provision under section 13.1 of the 1985 Act. It's worded, I think, in identical terms to section 60, which then followed of the VAT Act 1994. In any case where, for the purpose of evading VAT, a person does any act or omits to take any action, and his conduct involves dishonesty, whether or not it is such to give rise to criminal liability, he should be liable to a penalty. So the one matter I will just check overnight is that under that previous version of section 13, was there a similar section to section 67, which specifically in statute terms put the burden on HMRC with respect to that test? So I need to check that. But my point I make now is that you can see how this was a much more difficult question of separation, because unlike Schedule 24 and 41, it wasn't simply a passporting through of the underlying tax liability and passporting it forward to part of the penalty, because in this liability aspect of the penalty, it was interwoven with a mental element of intention to evade VAT. And so essentially, if there hadn't been dealt with as a whole in these proceedings, what would have had to have happened is you had to look at the assessment on its own as to whether there was an underdeclaration of tax just on an objective level without any mental element, and then looked at it again through the prism of whether there was a mental element and whether it was intentionally evaded. So it was a much more conflated question, intertwining a mental aspect that we don't see in the Schedule 41 or 24 penalty regimes, and thus one can see how it is much more challenging to separate than the clear scenario we have in this case. And I would distinguish it on the similar ground they did in Omar Minerals. The fourth point I wish to make in terms of submissions made by my learned friend is that because with respect to Schedule 41, that reasonable exception, the reasonable excuse clause, if you recall, the burden was on the taxpayer with respect to that, they run the argument, well, doesn't that infer that with respect of all other aspects of Schedule 41, doesn't that imply the burden was on HMRC? Because the statute specifically said with respect to the Section 20 reasonable excuse clause, burden on taxpayer, is there an inference that the rest is on HMRC? We say no. Firstly, as we'll come to in due course, the cases of Khan and Doorstep Dispensary make clear that the default position in penalty litigation, unless the statute says otherwise, is that the burden is on the taxpayer. Point two is that that argument isn't consistent with the fact that the burden is on the taxpayer in the concurrent scenario and the separate scenario, the first two scenarios. And point three is that that provision, that could equally be read as meaning that the burden with respect of the other aspects of bespoke aspects of the penalty fall upon HMRC, whereas the reasonable excuse clause falls upon the taxpayer, but that says nothing as to where the burden falls with respect of liability. So that largely concludes my submissions with respect of the first part of ground one. The only other point I wish to highlight is that the application of Article 6 to the tax liability aspects of a penalty doesn't just have an impact upon the burden of proof. Certainly there are, it could also impact upon, does it impact upon the disclosure regime in the FTT? And there certainly has at least been one case where that is now a live issue going before the Upper Tribunal. So if this court were to uphold the decision that Article 6 applies in a penalty alone scenario to the entirety of the proceeding, including the underlying liability, it's not just a question of burden of proof. Of course, those subsequent cases have to be determined on their merits, but it's just to highlight the fact that it is wider than the burden of proof. I now turn to the second half of my submissions with respect of ground one. To recap, this submission is that even if it is not possible to separate out the different parts of a penalty, the Article 6 parts, it is nevertheless still compatible with Article 6 that the burden be on the taxpayer with respect of the underlying liability aspect. And I make 4 preliminary points, and then I will proceed to make 4 preliminary points, and then make 5 core arguments. The first preliminary point, and I don't wish to overstate this, but just to flag it, is what is the test to be applied when there is an alleged breach of Article 6? And I say that in the context of the Upper Tribunal's wording at paragraph 131. So core bundle tab 6, page 109, paragraph 131. So paragraph 131 says, and I've read this paragraph before, but we will not follow this approach in this case. These are penalty appeals. The general rule is that the burden is on HMRC to prove all aspects of these appeals that relate to the imposition of penalties consistent with the presumption of innocence, Article 6.2. And here's the wording I just seek to draw attention to. We should only depart from that rule where there is a justified and proportionate exception to the presumption can be justified on the facts and circumstances of the case. So it's the word depart and exception that I flag to say other cases have worded the test in a more neutral way. Because as I'll briefly come on to, other cases have worded it, for example, is the alleged infringement nevertheless still compatible with Article 6? Is there an unjustified infringement of Article 6? So just to take the tribunal to a few of those examples, the case of Eurowines, which is in volume 2, tab 29, page 511. So this is paragraphs 32 and 33.
32 to 3.
So this is Lord Justice Richards. And here there was a question as to whether the reverse burden was compatible, and the wording is 32. The compatibility with Article 6.2 of the reverse burden of proof on the payment of duty depends, as Lord Bingham said in the Sheldrake case, on examination of all the facts and circumstances of a particular provision in the particular case. In my judgment, consideration of the factors relevant to this particular reverse burden lead to a clear conclusion that it is compatible with Article 6.2. So it's not saying departure from an exception, it's talking about what's being alleged is still compatible with.
I'm sorry, I'm having difficulty following this. I understand the point that you have to look at all the facts and circumstances. But what's the test that you're applying?
What
What are
we
you
say
asking?
is the alleged infringement, whatever that be, still compatible with
How
Article
do you
6.
decide that? On the face of it, it's not compatible because the state has placed the burden of proof on the individual. 6.2 says there's a presumption of innocence.
By saying it's still compatible with, arguably there's a difference in terminology that it's not the words depart an exception.
I'm not sure, I mean, you may be right, but I have to say with respect, the way I think human rights law should be approached is not to parse language, but to ask what are the underlying principles.
Yes.
And the underlying principle, it might be said, is as the Upper Tribunal summarised it in paragraph 131, which is normally the burden has to be on the state, because that's what presumption of innocence means. The individual doesn't have to prove anything. But there can be departures from, exceptions, qualifications. It doesn't really matter what word you use, but there are modifications of that. That's not a universal rule. How do you decide whether a departure, exception, modification, qualification, whatever you call it, restriction, limit, it doesn't matter what it is, something which isn't the norm, how do you decide whether that's compatible? You ask, is it justified and proportionate? And that seems to be, in substance, what the Upper Tribunal is doing. Now, you're entitled to submit they got it wrong.
Yes.
But I don't really have any difficulty speaking for myself in comprehending what the task was that they set themselves.
Right. It may be it's an overly syntactical submission, and so I'm aware of that. submission is it slightly feeds into, to say something is still consistent with it implies that it hasn't been breached, there hasn't been a departure from it.
Absolutely. I mean, that's the end conclusion you reach in a human rights case is that what is alleged to be a violation of a convention right, in truth, is not, because it is in truth compatible. And that's the language of the Human Rights Act. Section 6 says it's unlawful for a public authority to act in a way which is incompatible with a convention right. But the way you decide, along the way, in order to reach that conclusion, you may well have to go, if you say take a classic Article 8 case or an Article 10 case, you'll have to decide, first of all, whether there's been an interference with the right to respect for private and family life or the right to freedom of expression, and then, if there has been an interference, whether it complies with the requirements of paragraph 2. And if at the end of the day you conclude that it has complied with the requirements of paragraph 2, the conclusion is there is no violation because what's happened is compatible with the convention rights.
I take the point, so I don't want to, something that is in reality not one of my main submissions, dwell on it for too long. The second preliminary point I make is that Article 6 does not necessarily apply in the same way with respect to tax, penalties or surcharges as it does with respect to the hard core of criminal law. And this point has been made in several authorities, but I think if I just go to the Gisilla, which is probably the most authority of the Grand Chamber, so back to volume 2, tab 20, page 333.
Three, three, three.
333. This is paragraph 43 of the Gisilla case. So this is just above the passage where it talks about separation. And just above D, halfway along the line, there's a sentence starting, there are clearly criminal charges of different weight. What is more, the autonomous interpretation adopted by the Convention institutions of the notion of a criminal charge by applying the Engel criteria have underpinned a gradual broadening of the criminal head to cases not strictly belonging to traditional categories of criminal law. For example, administrative penalties, and then it goes on, customs law, etc. And then it goes on, tax surcharges, this is just above F, differ from the hard core of criminal law. Consequently, the criminal head guarantees will not necessarily apply with their full stringency. And paragraph 81 respectively, where it was found compatible with Article 6.1 for the criminal penalties to be imposed in the first instances by an administrative or non-judicial body. The passage I wish to highlight is tax surcharges differ from the hard core of criminal law, and consequently the criminal head guarantees will not necessarily apply with their full stringency. So just to make that contextual point, and a similar point has been made by both the Upper Tribunal in CF Booth and the Upper Tribunal in Kawaja, but it's very much along the same lines, so I won't repeat those passages. My third preliminary point, where I do want to spend a little bit of time, which I think is really at the nub of the issue, is that the burden being on the taxpayer can be compatible with Article 6, and it is not limited to situations where the taxpayer is seeking to raise a defence. And there are three cases I wish to take the court through. The first is the Upper Tribunal decision in Kishore, which can be found in volume 2, tab 33, page 626. and it's paragraph 36,
Sorry, which page?
626. So this, at this point, this case was dealing, I think, with one of the precursors to Schedule 24 and 41. I think it was Section 63 of the VAT Act. And Section 63 essentially passported forward a liability finding into the penalty unless the taxpayer could show a reasonable excuse. And it was being challenged on the basis of Article 6. And at paragraph 36, the Upper Tribunal says, on the second sentence, we agree with HMRC there is no general principle that placing the burden of proof on a defendant in the context of a criminal offence is necessarily inconsistent with Article 6. The second case is this court, the Court of Appeal, in the case of...
I'm sorry to take you back to... obviously I can read the sentence, but with all due respect to the Upper Tribunal, they're not setting out any test there. It's just observing that it's not always incompatible with Article 6 to place the burden of proof on the individual. We know that.
Yes.
Lots of cases in Strasbourg which say that, but they're not. Unless you show us some other passage, what's the test?
Well, it's really just to, in the context of my learned friend submissions, that normally, certainly in the Upper Tribunal, I don't know whether they can pursue them with vigour here, is that normally the burden being reversed or flipped is normally in a situation where it's a defence.
Oh, I see.
And I'm saying no, it's wider. The general guidance is it's not just limited to that scenario. So I'm just seeking to contextualise the point. The second point which makes that point clear is the Court of Appeal case of Eurowines, Volume 2, Tab 29, page 512. And right at the bottom of that page, paragraph 43. Page 513, paragraph 43 at the bottom. I should note a further submission made by Mr Bednam that while it may in some circumstances be right to reverse the burden of proof in relation to a defence, it cannot be right to do so as regards an essential element of the offence, and none of the cases has such a reverse burden been held to be compatible with Article 6.2. Mr Bednam modified this submission by accepting that a reverse burden might be compatible where the relevant element of the offence was within the sole knowledge of the defendant. There is nothing in the decisions of the court or in the judgments of the Sheldrake case to justify this distinction. It would be too formalistic to say that whilst a reverse burden in relation to a defence may be compatible, it can either or never be compatible as regards an element of the offence, or can be only compatible where the relevant facts are within the sole knowledge of the defendant. It is always a question of examining the reverse burden in its particular context and determining whether it is reasonable and proportionate.
That, if I may respectfully say so, that does set out a test, and it's a decision of this court, so it sets out, as far as we're concerned, the test, the finding of it, whether it is reasonable and proportionate.
The third case I wish to go to, which was a decision of the High Court, is one that my learned friend places a lot of weight on, King and Walton. But the submission I make is actually, once that case is properly understood, it is actually largely supports the position put forward by HMRC in our submissions. So if I could go to that case, which is in volume 3, tab 26, page 762. King and Walden being the earlier iteration of the King case that went before the Grand Chamber. This was where there was a guest house business. Assessments were issued for neglect or willful default, and penalties under Section 95 of the Taxes Management Act for fraudulent or negligent delivery of returns. One of the questions being is, do the proceedings engage Article 6? So if we just scroll up to the very bottom of page 761, we can see here what Mr. Justice Jacob is setting out is his reasons for holding that the imposition of penalties for fraudulent or negligent delivery of returns are criminal proceedings. And he goes through some of the analogous Engel criteria. But then at the bottom of paragraph 71, he says as follows, and this is the passage relied on by my learned friend. It is accepted that generally, leaving out of account section 46.2 and section 101, and I'll come back to section 101 in a minute, it is not for the taxpayer to show that the determination of the penalties was wrong. On appeal, the burden of proof lies on the Crown. In this regard, there is a clear distinction between a penalty determination and an appeal against an ordinary assessment, where the burden of showing it was wrong lies on the taxpayer. So that passage is relied on by my learned friend. But there's the caveat with respect to section 101. So if I can take the court to what actually section 101 related to, and that can be found further up the authority at page 756. So we see at the very bottom of 755, we're talking here about section 101. And then it goes to quote it at the top of 756. For the purposes of the preceding provisions of this part of this Act, which of course section 95, the penalty would have fallen within, any assessment which can no longer be varied by any commissioners on appeal or by any order of any court shall be sufficient evidence that the income or chargeable gains in respect of which taxes charged in the assessment arose or were received as stated in them. How that provision was then interpreted was subject to discussion on page 757 at paragraphs 47 and 48. Mr. Wolfe, who's the taxpayer, submitted that sufficient evidence in section 101 meant no more that in the absence of contrary evidence, the early assessment would be taken as good. Paragraph 48, Mr. Underwood for HMRC or the Crown accepted that submission had force and accordingly did not seek to defend that part. It goes on to the bottom of 48 to say this: the effect of section 101 was merely that those assessments would be taken as good unless the taxpayer could show they were wrong. And then again, going down at paragraph 53 on page 758, the issue in relation to all the penalty appeals is whether Mr King negligently made incorrect returns or statements. By virtue of the agreed construction of section 101, there is a rebuttable presumption that the income in respect of which the tax was charged as stated in the original assessments, Mr King seeks to rebut that presumption. So in other words, when dealing with that penalty provision under section 95, there was a presumption under section 101 that the tax was as per the assessment unless the taxpayer who had the burden showed it not to be. That is not a million miles away, if not entirely consistent with essentially our understanding of the approach with respect of the penalty alone scenario. Because of course under section 101, say a taxpayer hadn't even challenged the assessment and just left it there, so there was no prior judicial determination. 101 kicks in, the assessment is good unless you show it to be otherwise. So we say actually the case of King with respect to the old regime actually supports our stance and isn't contrary to it. And then there was then a question as to whether that provision was compatible with Article 6, and the court's ruling on that is at page 765. Where they hold the provision was compatible at paragraph 81. The suggestion on behalf of Mr King is that to the extent that the penalty appeals took into account a preliminary fact determined by the 1991 commissioners and the limited presumption created by section 101, there was a shift in the burden of proof contrary to Article 6.2. I do not agree. I think these matters amount to no more than an evidential case against Mr King. The true legal position is that the ultimate so-called legal burden at all times lay on the revenue. The 1991 primary facts and the section 101 presumption, which itself arises from the primary facts, form part of the evidence against him. Looked at it another way, there is no matter giving rise to the penalty determinations which the revenue have not at one or another point had to prove. So to say the burden of proof was cast on Mr King makes no sense.
Do you support that reasoning?
It's not as, there's clearly a distinct, the point that's been made earlier between legal and evidential burden, there is confusion in relation to it. I support the overarching point that that such a provision was compatible with Article 6, essentially placing the burden, the burden being on the taxpayer to rebut the underlying assessment was compatible with Article 6. So I support it as far as that. I suppose I would have respectfully been more nuanced in the wording, but the general thrust of it, that it's compatible, we do support.
I think you're entitled to rely on 82 as well. That does say that even if that were wrong, I would regard the presumptions as well within the reasonable limits permitted by 62. And Brown and Stott, which is a Privy Council judgment by Lord Bingham, sets out the relevant principle and cites Salabiaku, which was at that time the leading case in Strasbourg.
Yes. The fourth preliminary point I make goes back to the wording of the Gisela test. So if I could refer back to Gisela in volume 2, tab 20, page 333. And it's paragraph 45 again, and it's the point that if separation is not possible, the last line of the last substantive line of paragraph 45, the Grand Chamber says the court must accordingly consider, this is if separation is not possible, the court must accordingly consider that the proceedings in issue to the extent to which they determined a criminal charge against the applicant, although that consideration will necessarily involve the pure tax assessment to a certain extent. And so it's just the emphasis on the words to a certain extent, that even if we are in the situation whereby it can't be separated and Article 6 does apply, clearly Gisela didn't envisage it applying to its full extent, and there's clearly a point to be taken there. I'm now going to turn to my 5 core submissions as to why, if it's not possible to separate, the burden being on the taxpayer with respect of underlying liability is still compatible with Article 6. The first of those points is the guidance that's now been given twice, we say, by this court in Khan and Doorstep Dispensary, and the general principle that where a statute gives a right of appeal against enforcement action taken by a public authority, the burden of establishing the grounds of appeal lies on the person appealing, and that the ordinary presumption is that it's for the appellant to prove his case. Just before we go to the case of Khan, can I just go to the section 60 of the VAT Act, which by statute places the burden on HMRC with a certain provision. So section 60 can be found in volume 1, tab 6, page 49. We see here section 61 words in exactly the same terms as section 13 was under the 1985 Act, so we've already seen it in that capacity. In any case where, for the purpose of evading VAT, a person does any act or omits to take any action, and his conduct involves dishonesty, he should be liable, subject to subsection 6 below, to a penalty equal to the amount of the VAT evaded. But the point I wish to draw the court's attention to is at the bottom of the following page, page 50, the specific statutory provision, subsection 7, on an appeal against an assessment to a penalty under this section, the burden of proof as to the matters specified in subsections 1A and B above shall lie upon the commissioners. So it is in that context that I now ask the court to turn to the case of Khan, which can be found in volume 2, tab 31, page 580. dealing with a section 60 penalty in that case. Page 580, paragraph 69 makes it clear the burden lies on the taxpayer to establish the correct amount of tax due. And just above J, you get the point that it should be noted that this burden of proof does not change merely because allegations of fraud may be involved. In paragraph 70, it says, the other rights of appeal under section 83 of the 1994 Act have not been given such detailed examination by the courts. However, the general principle, in my view, is that where a statute gives a right of appeal against an enforcement action taken by a public authority, the burden of establishing the grounds for appeal lies on the person appealing. 71, that principle is well established in other statutory contexts, particularly where the relevant facts are peculiarly within the knowledge of the person appealing. And then the case goes on to cite 2 planning cases to support that proposition. Paragraph 72, it is true that in those 2 planning cases, that the statements in the former were expressed quite generally. There may, of course, be something in the nature of the appeal or in the statutory context which requires a different approach. For example, under the jurisdiction of the Transport Tribunal, it was held that whereas on an appeal against the refusal of a licence the burden lay on the appellant, that was reversed on an appeal against the revocation of a licence. See the case of Traffic Commissioners versus Muck. That decision turned on the construction of the particular regulations and the European directive on which they were based. So pause there. The fact in that case that the burden was on the state agency or the government was because statute said so. So my learned friend relies on that case, but it clearly falls in the exception category of where statute otherwise says so. And then the crucial passages here at 73 going on to 74. The ordinary presumption, therefore, is that it is for the appellant to prove his case. That approach seems to me to be the correct starting point in relation to other categories of appeal which we are concerned under section 83 of the 1994 Act, including the appeal against the civil penalty. The burden rests with the appellant except where the statute has expressly or impliedly provided otherwise. Thus, the burden of proof clearly rests on customs to prove intention to evade VAT and dishonesty. In addition, in most cases of proof of intention to evade is likely to depend partly on proof of the fact of evasion, and for that purpose customs will need to satisfy at least the tribunal that the threshold has been exceeded. But as to the precise calculation of the amount of tax due, in my view, the burden rests on the appellant for all purposes. So I'll just make a submission there in relation to the line, in addition, in most cases, proof of intention to evade is likely to depend partly on the proof of the fact of evasion. And for that purpose, customs will need to satisfy the tribunal the threshold has been exceeded. In my submission, what the Court of Appeal is there referring to is a specific wording of section 60, which says that HMRC need to make out intention to evade, and section 60 subsection 7, which clearly places the burden on HMRC. And because the fact of evasion is subsumed within intention to evade, the burden in relation to that is upon HMRC. What that is not saying, in my respectful submission, is that generally in all penalty cases, whether there has been an evasion or above a VAT threshold, that by default that burden is always on HMRC. That's not what that passage was saying. It was making specific reference to the wording of section 61 in the context of section 60 7, which put the burden on HMRC, and because the facts of evasion were subsumed with the intention to evade in that case. And when we come to it in due course, I suspect that was one of the reasons where the UT fell into error, we say, in their interpretation or understanding of Khan. It goes on at 74. This view is reinforced by a number of considerations. It is the appellant who knows or ought to know the true facts. Subsection Roman numeral 2, section 67 makes express provision for placing the burden on customs in relation to specified matters. This suggests that the draftsman saw it as the exception to the ordinary rule and seems inconsistent with an implied burden on customs in relation to other matters. Well, just to pause there, we rely upon that same point in relation to the Schedule 24 and Schedule 41 penalties. The default position, we say, is that the burden is on the taxpayer, and there's no exception to that rule in terms of a specific statutory provision placing the burden on HMRC. Roman numeral 3, the distinction is already defensible as a matter of principle. Mr Young relied on the presumption of innocence under Article 6 of the Convention, but is unable to refer us to any directly relevant authority. The presumption clearly justifies placing the burden of proof on customs in respect of tax evasion dishonesty, but once that burden has been satisfied, a different approach may properly be applied. And then it then gives further reasoning, but the other point I just wish to draw out is Roman numeral 6, which appears on the following page, 582, at line C. To reverse the burden of proof would make the penalty regime unworkable in many cases. In a case such as the present, a best judgment assessment is needed precisely because the potential taxpayer has failed to keep proper records. So the positive proof, in the sense required in the ordinary civil courts, is not possible. The assessment may be no more than an exercise of informed guesswork. Indeed, to put the burden on customs would tend to favour those who've kept no records at all, as against those who've kept records which are merely inadequate, but may be enough to give rise to an inference and balance of probabilities. So again, I draw an analogy to that final point there, is that if the burden were to be on HMRC with respect of the underlying question of liability, that very much rewards the alleged alcohol smuggler who hasn't kept any records as to the point or place of sale. And we say our interpretation of Khan was upheld in the Court of Appeal in the case of doorstep dispensary.
Can we leave that for tomorrow, please? So we'll start again at 10 o'clock tomorrow.
What, right,